Good morning. My name is Zachary Gibson for the state. I hope you all can hear me this time. Presiding Judge Keller, may it please the court.
Feel free to speak louder.
Okay, yes.
Please.
Presiding Judge Keller, and may it please the court, this case involves two grounds of review because the lower court committed two different errors. Although different, both, however, stem from the same root problem: an overly crabbed and picky appellate scrutiny of an otherwise valid criminal conviction. The holdings of the lower court below flouted both this court's directive to view the evidence in the light most favorable to the verdict and this court's directive to interpret legislative enactments according to a fair and reasonable reading of the text. The court below begins its error by holding that a rational jury could not infer that a man who wants to kill his own mother, who has testified against him at a protective order hearing, and who plans to testify against him at a trial about the same underlying facts, was doing so in retaliation for or on account of her testimony at a prior proceeding. The court reaches that conclusion by putting almost dispositive weight on the appellate's own stated motivation. This is the opposite of how other sufficiency review works in all other contexts. As many courts have noted, intent may be proven by a circumstantial evidence, and in fact, it is rarely established by other means. The Second Circuit has noted in interpreting the federal retaliation statute that direct evidence of retaliatory intent is rarely available to prosecuting attorneys. The lower court did not view the evidence in the light most favorable to the verdict when it refused to factor in basic and well-known motives of criminals and indeed most people. The lower court then compounded its error by reading the word witness, which has appeared in similar statutes going back to Blackstone, as meaning a person whose testimony is anticipated in court, in an artificially limited way of only meaning someone who has testified in an official proceeding. When one looks at the plain meaning of the word both witness and status, it becomes obvious that the lower court did not give the statute its fair readings. On both grounds, this court should reverse.
Let me ask you a question about that, because ordinarily when a statute, when a term in a statute is not defined by the statute itself, it's given its ordinary meaning. But what happens when the legislature comes in subsequent to interpretations by this court that might put guardrails around the term witness, and then says, well, they add another word to it, right? Like a prospective witness. Does that necessarily mean that to the degree that the term witness might have originally properly contained prospective witness as well, now it doesn't because the legislature has added that new term, prospective witness, specifically?
Well, it does. So let me answer your question yes and no. So in Jones, we concede in our brief that there is language in both Jones and in a subsequent case, Benson, that could be read that way, that witness in and of itself means somebody who has testified. If that is what it meant, then the court was going against authority from Maine to California, from Blackstone to the present. However, here's what Jones actually said. Furthermore, considering the requirement of Section 3606 supra, which is the retaliation statute, the prescribed conduct be in retaliation for or on account of the service of another as a witness, we must construe witness to mean one who has testified in an official proceeding. The court was interpreting or giving a definition for what it means to render service as a witness. That's the most intelligent way to interpret it. So here the question isn't just have they added prospective witness, they certainly did. They've also added the word status. I mean, the legislature has not always consistent about many things, but if there's one thing they're consistent on, they keep broadening it and broadening it and broadening it and broadening it. They want this to be broad, and they don't want picky, I'm going to read the statute and the evidence in the most uptight way possible. They want it to cover people.
So is the element, the substantive element in this statute, is it witness, or is it public servant, witness, prospective witness, or informant? You
It
see what I'm
would-
saying? Is that sort of a substantive element with all those options?
Well, it would be an element with those different options. They would be different manner and means. Now, with manner and means, they have to be supported by the evidence. In many cases where it's clear only, certain manner and means apply, you either just plead the ones that apply, or you maybe plead them, but then wait until it goes to the jury charge, and if there's no evidence of something, then you wouldn't submit it. Like if you have a DWI case and all the evidence is about alcohol, you may just have the generic intoxicated, but then in the jury charge, you would just have by introduction of alcohol, because there'd be no evidence of drugs. I mean, it would be purely speculative. So it's I think Kata called it a Chinese menu. But to be clear, there are two issues here. One is evidentiary sufficiency, the first ground, where even if you assume the lower court statutory reading is right, we still win. I mean, this is but as to the statutory interpretation, this is about if you're assuming that they're right about the evidentiary view, this would be whether she had the status of a witness. And she clearly did. I mean, witness has been used, it's used in everyday parlance, but between attorneys, so I'm using the legal definition of the term witness, is somebody who, it does mean somebody who testifies in an official proceeding. The case cited, Ulmer, that's all it says. It doesn't say has testified. In the tampering statute before it, it says somebody who is a witness. It does say prospective witness in one place, but then in the next section it says just witness. A person who commits an offense if with intent to influence the witness, he offers, confers, etc., a witness or prospective witness. So witness is generically a term that can be used to talk about somebody who's going to testify, who is testifying, who has testifying. The context is what shows whether it's, nouns do not have tenses, so you have to, it's based on context.
Page 1 of the Court of Appeals opinion describes the problem in this case as a fatal variance. But it then goes on to say that the evidence is legally insufficient. And I'm curious whether, is there a distinction between those two things? If it's a fatal, is the court signaling that it doesn't really know whether it's a fatal variance problem or a sufficiency of the evidence problem? And if so, what is the problem? Is it a legal sufficiency, or is it a variance between, what was sort of a notice problem? Is it a notice problem or a sufficiency problem?
It would be,
And
first of all, I'm
the
not,
Court of Appeals having used the word variance, fatal variance, in the first page of its opinion?
well, I certainly will not defend the conclusion of the lower court, but if something is a fatal variance, so I believe, Judge Zachary, correct me if I'm wrong, you wrote the majority opinion in Ram Johnson Singh, that's a difficult word to say, where it talks about where something rises to the level of a variance that affects legal sufficiency. Their whole theory was there isn't sufficient evidence that he had this intent based on past testimony. Now, we think that's somewhat ridiculous given the record, but that was their theory. And then the next thing is a fatal variance based on a, quote, distinct statutory term. And he is using the term fatal variance to refer to a problem with sufficiency of the evidence. We don't think it applies here. But I think that kind of fatal variance, according to Kata, does affect the sufficiency of the evidence, if that answers your question. If it were just a variance of something with manner and means, but it weren't a statutory one, if it were just like how you punch somebody in an assault, that would probably be a non-fatal variance. But back to the issue of the statutory interpretation, our argument is not just about the meaning of witness, it's about what status does to it. People have, it's been used in obstruction statutes. Blackstone used it, the predecessor to, I think it's section 1503, where they used to prosecute people for witness tampering, intimidation, retaliation, just use witness, and that was considered to cover people who were going to testify, people who have, because the context of these types of statutes, sometimes the proceeding or thing you're trying to obstruct could be in the future, or it could be retaliation for something in the past. As to the evidentiary sufficiency, the other problem with this case, onto the first ground of review, getting away from the statutory issue, is what it does to sufficiency of the evidence. And I think the best analogy is to a visual force perspective. This is forced evidentiary perspective. Yes, it is true, and we certainly concede that on the first ground where you assume that this needs to be directed at past testimony, it's true. The evidence that he has the intent to probably tamper and also retaliate because she's going to testify, that is overwhelming. I mean, it is to the moon and back, because he confesses. He gives an explicit confession of his intent when he's on the jail call. The problem is, if he had just given, and we cite, it's cited on page 16 of our brief, United States versus Johnson. It's a federal case, but it's where they have somebody where there's an attack on a witness's mother, and the person never says what their motive is, and the court's like, well, it's rational to presume that it's both. It's both retaliatory for the past testimony. I think he testified in front of a grand jury, and also because he was planning on testifying at trial. Those are just normal human impulses. Yes, it's true that here you have the explicit confession. Now, first of all, defendants don't normally get to confess what their mental state is and force juries to believe it. I mean, if that were the case, they would have very difficulty getting a conviction. But also, assuming that he had the mental state are not mutually exclusive, right? I could imagine a case where if you have one mental state and the evidence of that is overwhelming, that yes, you could not then go forward on another mental state. But here it's perfectly rational to think that yes, he was furious she was going to testify against him. He was also angry that she had testified against him in the past. He knew about her testimony. It was based on the exact same underlying facts that was part of the harassment case. He moved to quash the protective order. Just basic human motivations of criminals and people that are in the legal system. I don't know if you could say that a person getting a protective order is less likely to get retaliation than somebody that's getting testified against in a criminal trial. Most family law attorneys would probably not agree with that. So there is legally sufficient evidence that he had the retaliatory intent against the past testimony. It is circumstantial. And yes, one might be here and the other's here, but it's still, they're still tall enough to ride the amusement park ride just because somebody else is much taller. As to the statutory ground, I was covered it earlier in my conversation with Judge Yeary. The federal courts all interpreted witness to mean somebody who is going to testify, who is testifying, who has testified, because the context of obstruction of justice statutes is absolutely that those things are covered. In Jones, the court made very clear that it was interpreting that term along with service. And yes, somebody does need to have testified to an extent to serve as a witness. But having the word status, in fact, it is on page 44 of our brief, United States versus Davis. It's a federal case, and they're talking about the federal obstruction statute, the former version, and they use the word status, a witness's status. Status, in our view, is literally just nothing more than the use of the word to be. Somebody would say so-and-so is a witness in a case.
Is that something that, I'm just curious, I don't know the answer, is that something that has always been in the statute from the beginning, service or status, or is that something that came along later in some amendment to the language?
It did. It was added, I believe, in 1997. So it's
Both
been
words were added, or only one was? Did it start with one? And
well, it started out in the 1980 version. It was service of a witness,
okay,
and then in 1983, they added prospective witness, and then in 97 they added service or status. So now it's service or status of a witness. And the case that he relies on, Cotta, yes, was after the 97 amendments, but the state in Cotta, they apparently were using a very old pleading manual. They literally just charged based on his service as a witness. Also, Cotta is not really on point either, because any discussion in Cotta about the difference between a witness versus prospective witness is all dicta. The court said that the person there met neither definition. It was, they're the only definition you could reach under the facts of CATA without speculating would have been that the person was an informant, because he was, the defendant was angry that the person had called the police and a warrant had been found against the guy's wife, but that was it. There was no reason to think he would ever testify in court in any reason. So I see I'm out of time. I'm eating into my rebuttal. Thank you all very much.
May it please the court. My name is Mark Hochglaube. I represent William Solomon Lewis. What Mr. Gibson just told you is flat out wrong about CATA not applying or not having a holding that applies to the distinction between a witness and a prospective witness. I think the second sentence in CATA, and I'm quoting here, we hold that a variance between the pleading of one statutory element, a witness, and proof of another statutory element, a prospective witness or an informant, is material under Galahar. I mean, it just could not be more clear how CATA speaks to this particular set of factual circumstances. And, you know, to use a sort of cliche that we hear in law school a lot, we talk about attorneys pounding the law or pounding the facts or pounding the table. I would readily acknowledge that the facts in this case are ugly, and that the facts are not on Appellant's side. What he said was reprehensible, and it is difficult to resist the temptation to want to see him held accountable. And so I would readily acknowledge the facts lie with the state. But just as decisively, the law is on the side of Appellant. This is a clear case where there's a generation of case law holding that a specific definition applies to witness.
What is that definition that applies, and where does it come from?
It emanates from Jones, and the definition is a person who has testified.
And does that go to the jury? Do they get that definition?
Well, I don't think it necessarily does, but it certainly could be requested, and then the jury would get that definition.
Well, I mean, if looking in legal sufficiency, you only are going to say it's insufficient if no rational jury could have found. And you have to have the hypothetically correct jury charge to see what they should have been looking at. So must they get that definition from Jones? And if not, how would they know that the evidence really wasn't there?
Well, in this case, the defense did ask for that definition to be included. And my understanding, offhand, I don't know that I've double-checked the jury instructions to know what the jury received in this case. But it makes sense that it would have been included based on the conversations that I was reading last night. So I think the jury would have received that definition. And I think that it would have been clear to the jury in this case that the singular defense that the defendant was offering was that he had not threatened a witness, but that he had threatened a prospective witness. If that answers your question.
So you're saying that the jury charge should have said witness means somebody who has testified?
Yes, ma'am.
Was there an objection on that basis to the jury charge, or I'm just curious?
My understanding is that there was not I'm trying to recollect. I know it's in volume 16, the exact language of what the disputes were about the jury charge, but I know that the defense asked for an instruction defining the term witness because...
But even if they didn't get that instruction, you're saying they should have gotten that instruction, and that's what we should measure the sufficiency of the evidence against?
Yes, ma'am.
That legal definition of witness that comes from Jones?
Yes, ma'am.
Okay.
And to your question, Judge Erie, I would describe a variance as a form of insufficient evidence, Right? I mean, there's lots of different ways that the evidence could be insufficient. It could be that all of the witnesses who testified were not credible.
Well, you can have a variance that's not a fatal variance, but it's nevertheless a variance. It's, you know, you proved something that you didn't allege, and you don't acquit somebody on that basis always, you know, especially if it's not a fatal one, right?
For sure,
So,
for sure.
So that's what it makes me curious. Usually when you say the evidence is legally insufficient, for some reason, it's an acquittal, period. So that makes me wonder about what is this distinction between variance that we've recognized and legal sufficiency itself, like substantively failed to prove the elements of the crime.
And I would say that CATA is exactly the instructive case. The Galahar makes clear that surplusage and non-elemental variances won't result in an acquittal on appeal. But when there's a variance that goes directly to an element of the offense, in this case, the protected individual of a retaliation charge, right? In that situation, that becomes a fatal variance because what has been alleged is one particular element, and what's been proven is a specifically different element. And I would also submit that on the legal sufficiency points that the state thinks it's so obvious that this protective order was a contributing factor. I would urge the court just to review the transcript. I mean, and Justice Harvey, I mean, the state sort of relies on a case called Flores, in which Your Honor wrote a dissent, basically. And the state deduces from this that, the only time you can really deduce a person's intent is when they confess. That's what this phone call is. I mean, basically, the state just said he confessed. I mean, he confesses. It's just he confesses to a specifically different illegal intent. And he is emphatic about it. And the reason why is because he doesn't want to go back to federal prison. And he's constantly talking about how this new charge of harassment against his mother has criminal implications that are liable to thwart his federal supervision. Whereas a protective order from months earlier, which, although the state says that he was aware of the testimony, he wasn't aware of the testimony. He was aware that there was a protective order, but he was not aware that she had testified in it.
What do you make of the difference of the words service or status? The state pointed out that there's potential that these words mean different things, perhaps, and I'm wondering, how does that fit into your argument? This language within the statute, I think within the charging instrument as well. Tell me if I'm wrong about that, but service or status.
Both are included in the charging instrument.
So are those different things, and can you explain what the difference is as you understand them?
Well, so I think, and this court has held that service and status as applied to prospective witness, which is not what's pled here, as applied to prospective witness, that basically there's no difference.
Well, but is that what our opinion said?
It is.
We said service. We were addressing under the terms service or status.
In Ortiz.
Not just service.
Correct. In Ortiz, service and status are both alleged in conjunction with prospective witness. And this court holds that basically it says there's little difference, but the inference to be taken is that there's not a difference, right, between those two as applied to prospective witness. But the court also says that service and status as applied to every other person or protected person under the statute, that there is a difference, or it basically suggests that. That's what the language suggests, is that prospective witness is the only type of protected person where service and status are the same.
I mean, I can see how you could say somebody has not served as a witness if they have yet to testify, right?
That's
I
correct.
can see that. If you have the status of a witness, that's a more difficult problem, because even in this case, you have testimony from someone saying, I think the officer saying that this person is, as in like now, the complaining witness, right?
Yes, sir.
So that means, I mean, to some degree, that person is a witness.
Well,
Do they have the status of a witness, perhaps because they are the complaining witness? Or
I do not dispute that the word witness, certainly in common parlance, is far broader than the definition that Jones gives it. But
No, but I mean, does the word status enhance our understanding of what a witness can be?
And I would say no, because if you look at what the sort of evolution of this line of case law, right, the first change is that Jones comes along and says witness is only to be a person who has testified. And it's exactly to your point, based on the fact that at the time, service was the only possibility. And for a witness to have served, they must have testified. Right? And Jones makes that part clear. In response, and this court has held it's specifically responding to the Jones opinion, the legislature adds the contradistinctive term prospective witness. And what you find is that then, about 15 years later, the legislature adds not just service, but it adds status to it. And the legislative history makes clear that the reason for that adjustment had nothing to do with witness or prospective witness at all. It was based on the fact that they wanted to alter they wanted for public servant, which is another type of protected person, right? They wanted to be able to prosecute cases when a public servant status or a public servant's service was involved. But
So if the term status would be defined to include someone expected to testify, that would render the term prospective witness.
Totally obsolete.
Would be, yeah.
Completely obsolete. And this is to the questions you've been asking all morning about what kind of language does this cause problems with in prior cases. Mm-hmm. Throughout all of the cases involved here, from we're talking about Jones and Benton and Morrow and Ortiz and Cata, every single time this court speaks to this issue, it says that each of these items, prospective witness, public servant, is distinct.
So if the state had just pled witness, we might be in a different place?
If they had pled prospective witness.
Okay.
If they had pled prospective witness, we wouldn't be here. But additionally, I mean, just to reemphasize how clearly Cata is on point, right? The whole reason why the defendant, and anybody that looks at this case will see that my client is a litigious individual, and the volumes I think are 30-something in nature because there were constant hearings and whatnot, and there's Ferretta hearings and whatnot. He's the one who identified this. He's the one who actually read this court's opinion in Cata. And unfortunately, the prosecutors did not. And if they had, I think, undoubtedly, they would have pled this case differently. And this is what's sort of, troubling to me as I read this. The solution here is not to rework, a half a century of jurisprudence. The solution here is for prosecutors to plead their cases correctly. That's what this was just a mistake on the part of the prosecutors.
So, counsel, you talked earlier about elements, and you talked about proving one element, but the other element has another element. Is your theory here that let's say we say, okay, fatal variance, insufficient evidence, would a subsequent prosecution of your client for a prospective witness be jeopardy barred?
Well, it would not be jeopardy barred. At this point, it would be barred by the statute of limitations.
Okay.
But it would not be jeopardy barred. At least, and I'm not sure I've thought to that, but they are different elements under Blockberger. They're just being disparate elements. It would seem to me that the charge would not be
Is there any
jeopardy barred.
limitation on the legislative, on the legislature such that they cannot define or provide options for elements of an offense that have overlap? Can they do that? I mean, I'm thinking about
Absolutely.
in my mind like a situation where somebody is both over the age of 65, so they're elderly, and they're also disabled, right? And let's say that the evidence shows one but not the other, and both of them in this hypothetical statute I'm thinking of are different options, right? So I'm wondering if you could be both, in some sense, a witness and a prospective witness at the same time, such that the jury could, even though you didn't plead prospective witness, and there's one sense in which you might be only a prospective witness, there may be another sense in which you already are a witness. at the same time.
And I don't quarrel with the idea that there's overlap. In fact, all of the cases from this court suggest that there is overlap. That's what Ortiz says about, status and service of a prospective witness basically being the same, just as those two words cover to prospective witness. The problem is that all of these words have to have at least some distinction. There has to be a place where they are distinct. And
So they have to be different.
well, there has to, I would submit that if you're gonna assume the legislature had an intention when it added the language prospective witness, then you have to give that meaning. And that's, and it was made in contradistinct, it was made as a contradistinct category to witness, specifically because of this court's opinion in Jones.
Right. What if the state had what if the appellant had simply threatened to kill his mother and, there was no, without saying any indication why, just gonna kill her. I hate her, I'm gonna kill her. He didn't even say he hated her, just gonna kill her. Do you think that would have changed, the finding by the Court of Appeals as to sufficiency?
It might have. It might have. What is so striking about this phone call, and in many ways for worse, is just how specific he is, right? I mean, he is just spot on specific about asking about whether she's going to testify in the upcoming case and asking about whether or not she realizes that this is going to send him back to federal prison and asking, he does this repeatedly. There's no mention of some protective order. There's no mention of anything about the process that's happened in the past. It is all about what's happening in the future. And yes, he's mad at her for a litany of other reasons, although the protective order never comes up. But it is just the specificity with which his statement is repeatedly said that he is specifically trying to address her future role as a prospective witness. And so to the extent that if he hadn't been so specific, if he just said, if he'd been out of custody somehow and he'd said, I want to kill my mom, then you get into questions of how does it connect. And I wanted to address this because I didn't include anything about this in my brief, but if you look at the causation statute, which is not exactly applicable because causation is whether a defendant is culpable when there's concurrent causes, right? But it's a really helpful sort of analysis because what it says is that when there's multiple causes, if the cause that's part of the charge could not have caused the result, but the concurrent cause could have on its own caused the result, then there's no culpability, right? And in this case, it is undoubtedly clear that it is the future testimony that is causing this threat. And that, undoubtedly the defendant and his mother had a very complicated relationship and tempestuous and problematic. And we can look at this from a butterfly effect analysis and go back to the time that he was an infant and was crying for his bottle, and how all of this ultimately led to where we are today. But when you talk about causation, and I would submit that the language of the retaliation statute goes beyond just normal causation because it speaks to on account of and in retaliation for. It is a very quid pro quo type of analysis. And when you're speaking to that, there has to be a causal nexus between the actual intent of the person and the service or status of that person's role in their protected category.
Does this boil down to only an issue of failure of the state's pleadings, or is it something about which the defendant didn't have sufficient notice? You see what I'm saying?
I do. I don't think this is about notice, Judge.
I think he kind of knew what they were coming after him for.
What I think is that the defendant looked at this pleading, looked at this court's opinion from Cata, right, and concluded that what he was charged with was not what he had done. Mm. And I think that ultimately when they got to the court and the defense initially made its motion for an instructive verdict, that everybody in the courtroom, the state included, agreed that based on CATA, the state's initial presentation of the evidence had been misguided, and that they had pled it incorrectly. And the state, a couple times on the record, acknowledges we made a mistake in our pleading. And that was the singular basis of his defense, and that's why we're here.
Quick question. This is the case where the mother posted a cash bond for, is he still out of custody?
He is at large.
Okay, thank you. Thank you.
Thank you very much.
All right. A couple things. Mr. Hochglaube's comments were that the state was completely wrong about something. Let me just read to you from CATA. In the present case, the state alleged that appellant retaliated against Mr. Finch on account of the service of the said Arthur Finch as a witness. And then it goes on to say, under Jones, the state was required to prove that Mr. Finch has testified in an official proceeding. We do not take issue with that. This case is about what it means to have the status of a witness. There is no holding of this court that we are asking you all to overrule. All of the cases that he cites, CATA. Yes, CATA came temporally after the amendments, but the state did not put it to use. CATA, Benson, Jones, all three involved service of a witness. And Jones, as I mentioned earlier, specifically talked about the word service as being important to its interpretive directive. The other thing, too, is that you ask about the legislature using terms that overlap. Let me just make a very important point here. This is not a case of a statutory definition. So one of the leading treatises, reading law, this is section 36, definition sections are to be strictly followed, carefully followed, I think is the word it uses. If the legislature had written witness means somebody who has testified, yes, we would be locked in with that. In fact, it does that with the word informant. It does statutorily define informant that way. But here, we're dealing just with what is the ordinary meaning of witness. And Mr. Hochglaube said, well, in common parlance, it would be broader. Well, if in common parlance this would cover this, then the statute covers this. If the legislature wants to statutorily narrow just the word witness in and of itself to someone who has testified, it can do that. Instead, it's added the word status. And we cite the federal cases, examples of the Fifth Circuit case saying that somebody had the witness status when they met the longstanding definition of somebody who is going to testify. The rules of evidence do that. In the 600s talks about the sequestration of witnesses called the rule. Well, that applies to both people who have testified, if you invoke it after trial begins, and people who have not, and they're all called witnesses. Nobody is at a loss to what they're having the status of witness is.
Are you agreeing that the correct jury charge should have said that a witness is somebody who has already testified?
If it had just had the word service in it and not had the word status, we would agree with that statement. At the very end of our brief, and I don't know if the court needs to go this far because I think this evidence is legally sufficient, even on the has testified. Yes, it's true, he confesses to a mental state, but they're not mutually exclusive. It's like if one person confesses to a murder, that doesn't undo the circumstantial evidence that he committed another one. We give the federal definition of somebody who is a witness under their broad statute just to mean somebody who knows or is supposed to know material facts and is expected to testify to them or be called on to testify. And that definition prevailed in federal court for over a century. And also, back to Judge Hervey's point about redundancy, this is a case not where you can interpret the statute not to be redundant. This is a case where you have to pick between redundancies or ineffectiveness, I think would be a better word. Do you want to make witness and prospective witness, they're not fully redundant, but when you pair them with status, in a sufficiency review, I don't think they would overlap as a practical matter. Or do you want to make service and status almost totally redundant of each other, even when applied to witness? even when there's a history of witness having a broader meaning. And if you're stuck on, well, we don't know what to do, well, the state legislature has said the penal code is to be interpreted broadly and fairly. It's to give a fair reading. There's other redundancies here too. It says if somebody wishes to retaliate for or on account of. Well, close your eyes and imagine a situation where somebody wants to retaliate for but isn't doing it on account of. I mean, it's in Pujon versus Garland, Justice Kavanaugh said that obstruction of justice statutes are just written this way. They're written with belt and suspenders, they're written broadly, they're written redundantly, because sometimes legislatures want to be doubly sure. Sometimes legislatures may not always expect courts to be the textualists that we all should be, so that can be another explanation. I see I'm out of time. Thank you all very much, unless there's further questions. Thank you.
The case is submitted.